system, the amount the adjudicators are paid, the amount that the adjudicators can hear or are expected to hear, and the amounts that the claims are capped at, $6,000, has not changed. Basically, if any of you have ever seen either the People's Court or Judge Judy, it's exactly that without the attitude. So it's pretty much exactly that. You go in, you give your version of events, the other person gives his or her version of events. The rules of evidence are almost completely statutorily prescribed in the sense that any evidence can be accepted, whether or not that evidence could be accepted in a regular court. So you can come in saying, well, my neighbor's cousin's brother's sister's girlfriend's gardener told me that he heard that, and that's basically the end. Now, what weight you give that remains with the adjudicator, but the acceptability of that particular evidence is still there. So it is very, very informal. The whole idea really behind it is to have an expedited procedure and an expedited hearing for something that's worth a lot of money to some people, but not worth a lot of money in the grand scope of things. You consider that the courts can hear things to an infinite amount of money. $6,000 isn't really a lot in that particular sense. However, $1,000 to some people is an eternity's worth of savings, so it can be a lot to a lot of people. The claim forms are fairly simple. However, and here's my advice as an adjudicator, I wouldn't just, it has 3 or 4 lines to say, okay, what's your problem? Don't take 3 or 4 lines. Take as much space as you need. There's no extra cost for stapling a piece of paper to the back saying, see Schedule A or see attached sheet or something like that. Write it all out. The adjudicator gets the file. We then read through the claim, the response, and anything else that's been filed in the interim to give us an idea as to what we're going to be in for when the hearing takes place. So if I say, he stole my dog, and I want $50. Well, all right, that sort of makes sense. And then you get a 6-page response saying, well, not only did I not steal his dog, he stole my cat, and there was a bird, and oh my God, I'm going to go in and pick out the sofa. Like, all that stuff, and you get all this stuff back and forth, you have no idea what this thing's about. And I've seen, just amounts, lawnmower, $300 or something. All right, you either stole it or destroyed it, or I don't know what. So, take as much space as you need to explain your version of events. If when you come to court you realize, oh, well, I forgot to put something in, or I sort of said that, but it's changed since then, who cares? Just change it. It's very, very, very informal. Don't feel that you're going to be bound by the fact that you're not standing up and bowing the right way and wearing the robes and everything like that. You give your version of events and take as much space as you need to flesh out your version of events. I wouldn't attach things like statements from other people and letters and things like that. Wait until you get there. You can attach that, and there's nothing wrong with that, but I would wait until you get there and give that and have copies for everybody else and make sure that everybody's on the same page. So you're not passing around a letter from all the different parties so that everybody has a chance to read it before it goes any further than you understand. The response, the same thing. Once you get the claim, once it's filed and served on you, and I'll get to that in a minute, you then have 30 days from the time you were served to file your response. Don't just write in, no, he's lying, and put it in there. Flesh that in. Give your version of events for that as well. Take as much space as you need. You'll then file that with the court. The court will mail that out for you, and then a hearing date will be granted. Now, if you're suing somebody, you have to serve them. You can do that personally. You can walk up and say, here's the claim form that's been stamped by the court and that I've filed. I'm now serving you when you have to serve them personally. And you have a certain amount of time in which to respond. There are different ways of doing that. You can get a process server to do that for you. It'll likely cost you about $70 or $80 to get that done. You can recoup that. So if you're successful in your claim, the court will take that into consideration when they're awarding costs. Now, costs I'm going to get to a little bit later, but those are greatly misunderstood. But whatever out-of-pocket costs that you would have in terms of getting to court, you can recoup those. So you don't necessarily have to write that down on this form. You can explain that when you get to court. So once you get the claim, you'll wait 30 days. If no response is filed, you can then ask for a judgment to be entered by default, or you can request that one be entered by default. There's a form for that I've got in here too. Depending on the amount of your claim, if you said, look, he took my television, which is valued at $698.97, HST included. There you go. There's your amount. It's nice and cut and dry. Well, or he destroyed my lawn. I have a rough estimate that it's going to be worth approximately $1,500 to repair. One of two things can happen. You'll either get a judgment for the exact amount because it's very clear, or you'll have a hearing to determine how much the amount is going to be. At that hearing, the person who didn't file the response can show up, and they can make an argument against the amount. Now, that argument may not go very far because they didn't take the time to file their response, but they could still show up, or you could still show up, and you can still make your argument. It's possible that you could still file a response that the adjudicator allows for it. I wouldn't hold your breath, but that is a possibility. After that, you'll get your notice of hearing if the person does file a response. The notice of hearing is very important. I can get into that once I pass it all around, because it does tell you what to do, which means you should read it. A lot of people get it, oh cool, here's my date, and they stop there. They see the date, they see the time, and then they file it in the drawer, and that's it. Everything in terms of what you need to do is in the following paragraphs. You need to bring your witnesses with you. You need to bring your evidence with you. If you don't understand the language that the other person is claiming in, you need to tell us. You need to phone the clerk's office, the number's on there, and it says in the paragraph, if you do not speak English and or French, the number is in there, please call us, an interpreter will be there. The interpreter will cost you nothing. It's provided by the province. I've had a few people show up, I speak English and French, but the parties don't. So I'm not going to sit there and translate back and forth. I'm not the UN. So I'm there to hear what their claim is and render my decision. So people will show up and say, I don't speak any French, or I don't speak any English. And in that instance, you have to say, well, you have to go down to the clerk's office, tell them that, like you should have done when you got your notice of hearing, and then we'll schedule another hearing in 6 or 8 or 10 weeks, however long it's going to take to get another courtroom and to find another adjudicator. So read through the notice that you get from the court, read it thoroughly. If there is anything that you need, do so. If there's nothing you need, then just show up and be there on time. And that's about it. After that, you have your hearing, you can have your decision. The decision has to be in writing. The adjudicator has to render a written decision. You then have a certain period of time in which to figure out what it is you want to do. If you've won, you can try to collect. If you've lost, you can decide, well, the appeal process is slightly different. What happens is there's a form for that too, and that's in here. You can request what's called a trial de novo, which is it's basically a mulligan. You get a whole new kick at the can in front of a judge this time. So you get bumped up on the digital food chain to the Court of Queen's Bench judge. He or she will then hear the matter completely new. They know that the decision's been rendered by an adjudicator, but they don't see it. All they see are the pleadings. If I've rendered a decision that's been appealed by trial de novo, the judge doesn't see my decision. He or she only sees the pleadings, and then hears everything all over again. So it's a whole fresh start. And then you go in, you make your argument, you can bring a lawyer with you if you feel that might help you this time. Again, it depends on how much your claim is for, because your lawyer might wind up costing more than your actual judgment. Or what lease you've signed the standard form of lease. So whatever creative and drafty lease that you come up with, it's useless. The standard form of lease is the one that you officially have. Great. If you can, again, that's what I'm here for. So give me your version of events, and we'll just go from there. But you should try to settle it, because while you think you've been screwed, and you quite likely have been, there's a good chance that the other party thinks the same thing. And they're going to be just as passionate and just as ticked off as you are in making their argument. I've seen some gratuitous art. You can't say that even though it says you have to give me 3 months notice, I want you to give me 6. That won't fly. You can't change that aspect of it. You can add a whole bunch of other conditions, though, because it is your property and there are your rules. The only thing that's governed by the rentalsman is the damage deposit, the terms of the lease itself, and the nature of the tenancy. So by you saying that, well, you can't have this, you can't have that, you can't do this, you can't do that, damage deposit that you get, if you get one, will be eventually, is given to the rentalsman within 7 days. The rentalsman must have the damage deposit. If the rentalsman does not, you're committing an offense under the residential tenant rule responsibility to give it to the rentalsman. It is in your best interest to do that, for the simple reason that if the tenant leaves and then doesn't give you the rent and skips out, you have at least the damage deposit there. You make your claim to the rentalsman's office. This person left. They never gave me notice. I asked them for the rent. They were gone. Within usually about 6 weeks or so, you'll get your rent back. You'll get the damage deposit back. If they fight it, saying, well, this place was awful and it was really cold and, I never really heated it properly and all this other stuff, they can make that argument.